Lordship, kindly see the punishment order, annexure 18, page number 65. Lordship, petitioner has been inflicted with
What is the order dated 22/1/2008?
22-1 punishment order, Lordship.
What is the punishment?
Punishment is delinquent should understand the importance of job in future. Warning, number 1 punishment warning. And number 2 that delinquent shall receive only the subsistence allowance for the period of suspension. Lordship, in this case, what happened that in inquiry.
No, the first one is not in respect of warning.
Pardon, Lordship.
It does not amount to warning. The delinquent should understand the importance of job in future. That's all. It does not amount to penalty. Show me the list of penalties. Where are the rules?
Rule 14, Lordship, minor and major penalties.
Correct. In the minor penalties, show me that the employee should understand the importance of job in future. Is it one of the penalty?
No, Lordship, but second is amount to penalty.
All right, we will examine one by one. First one is not a penalty.
Lordship, but Lordship, it is a type of a stigma for me because no. Lordship, it is on complete baseless.
No, it has been just informed you. You should understand the importance of the job in future. That's all. It does not amount to penalty.
But I have done no any misconduct, Lordship.
All right, sir. We'll examine, but it does not amount. I will hold that it is not a penalty. You have been placed under suspension during which period?
Lordship?
You have been placed under suspension during which period?
21/8/2006
to
21/8/2006, Lordship.
To up to what date?
To 22/1/2008. 22/1/2008.
What is the allegation?
The main allegation against me that there was instructions for me to make a format to type, but in
where is the charge memo?
Lordship,
where is the charge memo?
Charge memo annexure 12, Lordship. Page number 42, annexure 12.
It is in Hindi?
Yes, Lordship.
Read the first charge. How many charges are framed?
1, 2, 3, 4, 5, 6. 6 charges, Lordship.
6 charges. All the 6 charges were proved?
No, Lordship. In inquiry, I am completely exonerated. No any charge has been established.
Inquiring officer has exonerated you
yes.
of all the 6 charges?
Yes, completely.
Then disciplinary authority?
Then what happened, Lordship? Without any second show cause, on a recommendation of secretary was not my disciplinary authority, even he was not inquiry officer, but on a recommendation of him, without hearing me, punishment order has been inflicted. Without
which punishment?
Lordship?
Which punishment? That is 22/1/2008 has been passed.
Lordship.
You have not been provided show cause notice?
No, Lordship. Second show cause notice.
Yes, who is appearing for respondent?
Yes, I am appearing for the department.
We'll allow the petition.
No show cause notice.
All right, I will allow the petition. Inquiring officer has held charges were not proved?
Yes, inquiry officer held that the charges were not proved, but the superior authority differed from the disciplinary proceeding was not exonerated.
Petitioner has prayed for the following relief. The petitioner was subjected to disciplinary proceedings on certain 6 charges. Twist of the inquiring officer held that the charges leveled against the petitioners were not proved. First up, on receipt of inquiring officer's report, the disciplinary authority should have accepted or rejected the report if the disciplinary authority is disagreeing with the inquiring officer's report. On the other hand, the disciplinary authority proceeded to impose a penalty within inverted comma that the delinquent should understand the importance of job in future, and further he is entitled to subsistence allowance for the suspension period. Who is feeling aggrieved by the aforesaid penalty order, petitioner has presented this petition. Who is learned counsel for the petitioner submitted that the inquiring officer held that all the 6 charges framed against him were not proved. Therefore, imposition of penalty in the absence of a show cause notice if the disciplinary authority is disagreeing with the inquiring officer's report, punishment order is liable to be set aside. Further, it is submitted that when the charges were not proved in an inquiry, in such circumstances, treating the intervening suspension period as restricted to subsistence allowance is illegal and arbitrary. Per contra, and counsel for the respondent submitted that there is no infirmity in the order of penalty having regard to the opinion expressed by the disciplinary authority. Heard the learned counsels for the respective parties. Undisputed facts are that the petitioner was subjected to disciplinary proceedings on 6 charges. Of the inquiring officer exonerated the inquiring officer held that all the 6 charges were not proved. On receipt of inquiring officer's report, the disciplinary authority, if he is disagreeing with the inquiring officer's finding on each of the charge, in that event he had an option of remanding the matter to the inquiring authority to commence the inquiry afresh from the defective stage, or suo motu issued a show cause notice what is the error committed by the inquiring authority with reference to material information and seeking petitioner's explanation. None of the aforesaid action has been taken by the disciplinary authority. On the other hand, he proceeded to impose the penalty while treating the suspension period as suspension only. In other words, restricting suspension period to only subsistence allowance. This court asked the respondent counsel as to whether disciplinary authority had issued a show cause notice before imposition of penalty or not, for which it was submitted that disciplinary authority had not issued a show cause notice. In the light of these facts and circumstances, the petitioner has made out a case. In the light of these facts and circumstances, the disciplinary authority's order in respect of imposition of penalty that within inverted comma the delinquent should understand the importance of a job in future is not one of the penalty identified under the penalty rules as one of the penalty. Therefore, the disciplinary authority stating in his order that the delinquent should understand the importance of job in future is not one of the penalty. therefore it does not amount to imposition of any penalty with reference to the disciplinary proceedings. Full stop. Insofar as restricting the subsistence allowance for the suspension period from 21/8/2006 to 22/1/2008 is concerned, when the charge itself, when the charges were not proved, therefore it is not appropriate for the disciplinary authority to treat the suspension period as a suspension only, while restricting subsistence allowance instead of full payment for the suspension period from 21/8/2006 to 22/1/2008. In the light of these facts and circumstances, the impugned order dated so and so stands set aside. The suspension period dated 21/8/2006 to 22/1/2008 is treated as a duty for all purpose of the respondent. The disciplinary authority / appointing authority is hereby directed to regulate the suspension period as a duty and extend difference of a salary for the aforesaid period and disperse the same within a period of 2 months from the date of receipt of this order. The petitioner is entitled to 6% interest on all arrears of salary to stop. If the petitioner is not paid arrears of salary for the suspension period within the stipulated period, in that event the petitioner is entitled to litigation cost, and it is quantified at rupees 10,000. Writ petition allowed.